Another one. This video is entitled, "What are the tax implications upon Marin County Sheriff and the Superior Court of California, Marin County, if they are found to be non-tax exempt by a 4172 letter in the process of serving an eviction notice?" So this video was prompted from article in the Marin IJ, Marin Independent Journal, by Cameron Macdonald, speaking on a Marin deputy injured while overseeing an eviction. So we asked AI or ChatGPT here, if a local sheriff is found to be not tax exempt from a 4172 letter, how does this affect an eviction where money was paid for this service? If a local sheriff is found not to be tax exempt under a 4172 letter, it can impact the eviction process in several ways, particularly regarding the payment for their services. One, tax implications. A 4172 letter generally refers to a tax exempt status determination from the IRS, often relating to certain government entities or officials. If the sheriff is not tax exempt, it may mean they need to charge taxes on their fees for services, which could increase the cost of the eviction. This could affect the parties involved in the eviction, as additional taxes may need to be paid. Two, refund of fees. If the eviction involved paying for sheriff services that were tax exempt, but it turns out they shouldn't have, there may be a situation where the payment needs to be reconsidered or refunded. If taxes were improperly waived or not applied, the person who paid may be entitled to a refund of the extra amount, or the sheriff office may need to adjust future billing. So in the case of this article, someone sued this person that was evicted from the article, and they were more than likely aware that the sheriff is not tax exempt here in Marin County. Three, effect on the eviction process. From a procedural standpoint, the sheriff's role in the eviction process is typically to serve notices and carry out the court order. If the sheriff's tax exempt status was incorrect, but the eviction itself was carried out properly, the eviction may not be directly affected. However, the financial aspects such as payments or billing could require adjustment or reconsideration of what fees are owed. So the court, as stated in the other videos, is not a tax exempt entity. You could scroll through the videos we made. Is the County of Marin or the Marin County Superior Court tax exempt? No. You could look at the video and get confirmation that they're not tax exempt from the letter that's in the video. In short, the primary impact would likely be financial, whether taxes should be applied or refunded, and possibly procedural adjustments in future transactions involving the sheriff's office. It is advisable to consult with a legal expert or sheriff's office to clarify the implications in your specific case. So yes, as stated, their transactions over $600, they should be giving out 1099s. And with the eviction notices, just one might be here and there, but they're doing many. This becomes capital gains, because as stated in the other videos, we're thinking that the sheriff is a tax exempt entity, even though they call themselves that, and we think they're sovereign, but it's not coming back when you audit them by the IRS. So here's another question that we put in the ChatGPT. What are the implications if an eviction is served by a local sheriff that is not tax exempt by a 4172 letter, and the local court that made the court orders is not tax exempt? as well from a 4172 letter. So this might be a little redundant, but we're just here to see what the AI says. If an eviction is served by a local sheriff and the sheriff is not tax exempt under a 4172 letter, and if the local court that issued the eviction order is also not tax exempt, there are several potential implications. Here are the key considerations. 1. Tax liability for the sheriff and court. Sheriff's office. If the sheriff is not tax exempt under a 4172 letter, it may be required to charge sales tax or other applicable taxes on fees for servicing related to the eviction, serving notices, conducting eviction. This could lead to the sheriff's office having to collect and remit taxes on the payment for eviction services, which may affect the cost for the party paying the fees, typically the landlord or the property owner. Yes, indeed, because someone has a tax liability. So with the court charging the fees and the sheriff charging the fees, and then they're under the guise of being a tax exempt entity, they will be liable for the tax because there is no documentation that exists exempting them from tax. So these transactions can exist in a sense that they're not tax exempt, because then they would have to correct all that stuff from previous years, and this will be a can of worms. Court's tax exempt tax status. If the court is not tax exempt, it may also have tax liabilities associated with its operations, including fees for filing court orders, serving judgments, or other administrative tasks. This could result in added tax charge on court fees and other services associated with the eviction process. So yes, they would have to bond their tax liability. A lot of the cases that they're overseeing in the court, they're not bonding them, and if they are, this is not for the public or the best interest of the public. So even if it's a private matter and they have a tax liability, they have to put up a bond because they're not a tax exempt entity. So they're, in a sense, double dipping and triple dipping if they're doing these transactions publicly and privately. The issue is that most people don't know this, and I'm not saying that a lot of people don't know this, but they don't know this to question, to find out the answers or the truth of the matter. 2, refund or recalculation of fees. The sheriff or the court is found to be inappropriately not tax exempt under the 4172 letter, they may need to adjust or refund fees that were paid in excess due to incorrect tax exempt status. The affected parties, e.g. the landlord or tenant, might be entitled to a refund of any taxes or additional charges that were improperly applied. This might involve a recalculation of fees paid for the eviction service and potential adjustments for the tax applied. The need for the sheriff's office or court to update the tax exempt status or apply laws correctly moving forward. So it's stated this is questioning the validity of their daily operations, including generating court orders and hearing cases, and the sheriff carrying out these orders, because now you have two political subdivisions of the state, so-called, working together, but they're not tax exempt. So then this becomes a problem because someone has to bear the tax liability. They're running these transactions and they're not paying taxes. And if they have a CAFR account or a financial statement that they're putting up yearly or quarterly or whatever, this would not be accurate. So these would trigger audits to fix this wrongdoing, but the wrongdoing has been going on for generations, so this will be a can of worms. 3, eviction process legitimacy. Eviction validity in terms of legal impact on the actual eviction order. The sheriff's and court tax exempt status should not typically affect the validity of the eviction itself if the proper legal process is followed. The eviction order is legally issued by the court and properly executed by the sheriff would generally still be valid. So if they're not tax exempt, they're not who they say that they are. So this would fall in the color of law, and the question of validity. So if they're not following their own rules, the whole thing would be invalid, even though this AI says contrary. So the service of process, the primary concern in terms of eviction and execution is whether sheriff service of process serving eviction notices carrying out the physical eviction was properly conducted, regardless of tax exempt status. If the process was carried out in accordance with the law, the eviction could remain valid. So if they're not paying taxes and they have a tax liability, who are they? So this is the legitimacy of the whole thing, to where if they were legit in who they say that they are, the validity would not be questioned. But since there is no paperwork or any paper trail of them being tax exempt, everything they do is in question and considered to be invalid, even though AI is saying contrary. For administrative and legal concerns, potential legal challenges. If either sheriff or court is found to be improperly charging taxes, there could be challenges regarding the legality of fees charged, which could lead to disputes between the parties involved. For example, tenants or landlords could challenge the largest as lawful if taxes were improperly applied or fees were incorrectly assessed. So it's stated all this stuff would be improper, and it's like the fruit of the poisonous tree doctrine. It is where the fruits that are bore from the tree will be also be poisonous. So their daily operations and whatever they're doing is in question, which would normally not be in question if they said who they were and they were who they said that they were. But since that's not the situation, all this would have to be looked at under a fine microscope and potential audit, as stated. Potential government audit: if the sheriff office or court is to have been improperly handling tax exempt status, it might trigger an audit or review by tax authorities to ensure compliance. This could result in corrective actions, including possible adjustments of the fees charged or penalties if taxes were mishandled. So yes, this is a problem, as stated, but the California auditor, Elaine Howe, would more than likely not want this to get out, because this would be more work for a whole team, and this would be a massive can of worms. So it basically say that, okay, well, if the court here in Marin and the sheriff here in Marin and the county here in Marin are not tax exempt, this is going to be can of worms. And then one could say, well, is Alameda County tax exempt? Is Solano County tax exempt? Is Anaheim County or LA tax exempt? So this would be more than likely they're not, and they don't want to get this out, because then the feds and all these people are going to have to do their job, and it's going to cause so many problems for them to undo all the wrong they've done under the guise of people thinking they're tax exempt. So 5, impact on future evictions. Sheriff and court may need to reassess and revise their tax exempt status going forward to ensure they are correctly applying tax laws. This could affect how they handle future cases, the amount of fees charged, and the proper taxation of services. So if they're not tax exempt as stated with the proof in the videos, then this is a problem, because one will question, is the stuff they're doing valid? So in conclusion, the most likely direct effect would be financial adjustment, potentially refunding or recalculating any excess taxes paid during the eviction process. However, unless there is a substantial violation of tax law, the legitimacy of the eviction itself should remain intact. It is essential for both the sheriff and the court to address and rectify their tax exempt status in accordance with 4172 letter to avoid future complications. Consulting with a legal expert or a tax advisor and is recommended to resolve any financial discrepancy. So let me type something else in. If local sheriff is not tax exempt and the local court is not by a 4172 letter and the fees are not accounted for in an eviction process, and the money is potentially laundered. What are the implications? So if local sheriff and court are both found to not be tax exempt under a 4172 letter, and if fees and eviction parts are not properly accounted for, there's a possibility of money laundering. The situation becomes more serious in both legal and financial risks. Money laundering generally involves the origin of illegally obtained money by passing it through legitimate businesses or financial institutions that make funds appear as if they were obtained legally. So you were thinking that the fees or funds obtained are legal. The question is, if both of the entities are not tax exempt, then the funds could possibly be illegal. If eviction fees are not properly accounted for, there is an intention or indication that the funds are being hidden or moved inappropriately. It could raise suspicions of money laundering, suspicious financial activity. If the funds collected during eviction process, sheriff's fees or court filing fees are not properly recorded or accounted for, if they are being transferred in unusual ways, being funneled through other accounts or entities, this could trigger investigation for financial misconduct, including money launder. Reporting obligation. Financial institutions, governmental entities are required to report suspicious activities to agencies such as Financial Crimes Enforcement Network, FinCEN, in the United States. Money is being funneled through the sheriff's office, court system, and other government entities in a manner inconsistent with lawful tax exempt status. Or proper financial reporting, it could trigger such reports and lead to investigation. So it's stated this is a serious matter if they don't have the paperwork stating they're tax exempt. Legal implications. Criminal charges. Money laundering is a serious federal offense that can carry significant criminal penalties, including imprisonment, fines, and asset forfeiture. If money laundering is suspected, the individual involved, whether they are government employees or private parties, could face criminal charges. This could include charges against the sheriff or court officials if they are found to be knowingly facilitating the laundering of money through the eviction process. And basically, that's what it is, because the county, the court, and the sheriff here in Marin are all not tax exempt. And they have facilitated this eviction against this man by the name of Kenneth Laddish, allegedly. And this is a problem. Civil liabilities. In addition to criminal charges, those involved could face civil lawsuits, including claims for damages, restitution, compensation for any harm caused by illegal activities. So yes, they would have to be liable because they're not who they're claiming to be. And this could be problems because they're trying to do legitimate things, but their foundation or their entity is not tax exempt. So breach of fiduciary duty. Public officials such as sheriffs or court officers have a fiduciary duty to act in the best interest of the public and follow the law. Failing to properly account for fees or engaging in illegal financial practices could result in breaches of this duty and lead to disciplinary actions, including removal of office. So it's stated from the other videos, when we asked the sheriff and the county to provide a W-9, they refused. So this is a window or peek into the fraud. The court gave the W-9, and when the W-9, we ran the audit on them, they're not tax exempt. So more than likely, the county and the other, the sheriff are hiding something. Reputation and trust issues, loss of public trust. If the sheriff or the court system is involved in properly handling fees, especially if money laundering is suspected, it could severely damage the reputation of these public entities. The community may lose confidence in the fairness and transparency of the eviction process, leading to public backlash, legal challenges, and a loss of credibility for the institutions involved. So not to be redundant, but the whole process that they're running from the outside is looking like it's legitimate. But after you have all the paperwork stating that they don't have the status, this becomes the problem. Increased scrutiny. One, suspicions of money laundering or improper financial handling are raised. Local government officers may face increased scrutiny from auditors, regulators, and law enforcement agencies. This could result in deeper investigations, audits, potential sanctions from oversight bodies. Impact of the eviction process. Validity of eviction. If it is determined that eviction fees were improperly handled or used for illicit purposes, the eviction process itself could be called into question. For example, tenants might challenge the validity of the eviction if the fees were not properly processed or part of a criminal activity. So it's stated you have the three entities working together: the county, the sheriff, and the court. None of them are tax exempt, so this can be RICO racketeering, and all this stuff would be invalid because they're doing things that are underhanded. Financial repercussions. The financial irregularities could also lead to the need for refunds to the affected parties if it's determined that improper fees were collected or laundered. Affected individuals may seek legal remedies to recover any fees paid for the eviction process. So yes, if these transactions are made to look legitimate, but they're not, there is recourse by the grace of God. Tax implications, tax evasion. The fees charged for the eviction process or other related services are not properly accounted for due to the lack of proper tax exempt status or fraudulent financial practices. This could be considered tax evasion. Both the sheriffs and the court system may face legal action for failing to comply with the tax law. So yes, this is true, but they would argue that this is a threat to public safety and public interest. The truth of the matter is that they're operating in a manner that is a threat to public safety and public interest. But this would make a huge can of worms, and those three entities might owe a lot of people for damages and the harm they cause under the guise of them doing legitimate business. IRS scrutiny. The IRS and state tax authorities may launch investigations if they suspect the funds are being misappropriated or if there is a lack of proper documentation for the fees. Any tax evasion or failure to account for taxes could result in fines, penalties, or even criminal charges for those responsible for handling the funds. 6. Potential investigations. Law enforcement investigations. If there's evidence suspicion of laundering or other crimes, law enforcement agencies such as FBI or state police may be involved in investigating the sheriff's office and the court system. Investigations could focus on tracking the flow of funds, any illicit activity, and prosecuting those responsible. That's if they do that. They might turn a blind eye, but I'm not God to say that, but more than likely they'll turn a blind eye. Audits and oversight. Local government entities, including the sheriff's office, and the court, may be subject to audits by state or federal agencies to ensure compliance with tax and financial reporting laws. These audits could uncover improper financial practices leading to further legal and financial consequences. So if they're not tax exempt, then these transactions can't exist because then they would be tax liable. Potential legal recourse for affected parties. Refunds and compensation. If tenants or landlords were harmed by improper fees or financial practices, they might be entitled to a refund of any improper fees or compensation for damages. Legal action could be taken against the sheriff's office or the court to recover any losses caused by the mishandling of funds. So, conclusion, combination of lack of tax exempt status for sheriff and court, unaccounted fees, and potential for money laundering creates serious legal, financial, and reputational risks. If money laundering is suspected, this could lead to criminal investigations, criminal charges, civil lawsuits, and penalties for those involved. Additionally, the legitimacy of the eviction process could be questioned, and the parties affected may seek legal recourse to cover any improper charges. It is critical to address these issues immediately to prevent further legal and financial consequences. So back to this article written by Cameron Macdonald of the IJ, basically saying that a San Rafael man was arrested on allegations he injured a sheriff deputy during an eviction. Friday morning at residence on Vioxx Way, deputies gave the man time to collect his belongings and leave. He refused and demanded to speak with his attorney. Sheriff Sergeant Adam Schermerhorn said suspect tried to re-enter the residence, essentially slammed the door on the hand of the deputy who attempted to keep him outside. Schermerhorn said the deputy required 3 stitches. Kenneth Laddish, 60, was booked in the Marin County Jail on the suspicion of injuring an officer, obstructing authorities, and disobeying a court order. He remained in custody in lieu of $50,000 bail. So there did this to this man, but it's stated this could be questioned because the sheriff is not tax exempt. all these entities are not tax exempt. So do they have the jurisdiction that they're claiming to have? Does the Constitution refer to them as being legitimate political subdivisions of the state if they're not tax exempt? So this is all color of law, and this is not true to what it is they're doing. So all this would have to be corrected, but this would cause major problems because they would have to correct a lot of the wrongs they've been doing. And this is also RICO racketeering because none of these agencies are tax exempt. It was stated, look at the other videos regarding the tax exempt status of the county of Marin, the county council, Marin County Superior Court, and Marin County Sheriff's Office, and that will give you the confirmation from those videos where those letters stating that they weren't tax exempt entities. So thank you very much. Good night.